respectfully, but we would need to take those pleas or handle those dismissals before the 16th. That's not what we would be doing that day. That's a day to pick a jury. So that sets a good time frame, and the sooner we can sort it out, the better. But I'll let you, Mr. Monetis, manage that as you coordinate with Ms. Charles. Okay?
Yes, Judge. Thank you. I agree.
All right. Anything else on behalf of Mr. Wolf?
Not at this time, Your Honor. May we be excused?
Well, let me find out. Mr. Wolf, you have any questions?
No, sir.
All right. Ms. Charles, anything else in connection with Mr. Wolf? I know he's got some co-defendants, but Mr. Wolf in particular.
No, Your Honor.
All right. You are free to go. Thanks for joining us.
All right. Thank you, Judge. Good to see you.
Same. All right. That gets us to position 11, Terence Cole. Hey, Mr. Cole? Good morning. Ms. Wood, tell me what you think is happening with Mr. Cole's case. Okay.
So I'll come back with an update after the call.
Excellent. So, Mr. Cole, you should sit tight. You and Ms. Wood need to talk. You may have heard, but the case where you're a co-defendant with Mr. Wolf is the one that we'll likely try first of Mr. Wolf's, which would mean you'd be going to trial as well, unless there's some reason to sever you or you've resolved your case. So you and Ms. Wood have something pretty important to talk about. You should stick around till Ms. Wood says it's okay to go, because you two will talk and she's going to give me a report. It may be we're sorting your case out today, okay? Yes? Great. All right, and we've got Mr. Wolf again. Mr. Jackson, Quintavious Jackson, is in custody, and he is one of the people here, and this is Mr. Bowles again. So tell me, Mr. Bowles, what your plan is with Mr. Jackson. He has many moving parts on the unindicted side of things. I know you and Ms. Convery have been talking about this. That's when I learned the sad news that if you aren't able to sort out this case and your other one in the near term, we have to say farewell to you and bring in another attorney.
Right, Judge. He has two open indicted cases. One has several co-defendants. Then there are the open unindicted cases. So what I've been waiting for, and I've talked to, because another prosecutor called me last week and was about to give me an offer till they found out that he has this open case, the other open case, the with the guns and the drugs case. So they said, well, let me talk to the gang unit, get a global resolution and give you that. So I'm still waiting on that.
Okay, so you haven't received that piece. I misunderstood Ms. Convery. I thought you had already received it, but she's going to get that to you. So it sounds like Mr. Jackson is somewhat like Mr. Campbell, where if it's something that makes sense, you'd be willing to help Mr. Jackson get there, but you need to get that offer from the state, and then you'll meet with Mr. Jackson. And if you and he are comfortable, it may be you resolve all that. If it's something that needs to go to trial, you were not retained by Mr. Jackson, you were appointed to Mr. Jackson. Is that correct?
It's all correct, Judge.
Okay. Well, let me turn to Ms. Convery. Ms. Convery, what's a time frame in which you could connect with Mr. Bowles to talk business?
This is actually going to be Mr. Harris, but it's fine. We're the same. We actually sat down in the week after the court's.
Did you tell me though at once it was because I wrote your name down?
Yes.
Okay. All right. So I should change it to Parrish.
Technically, but it's really fine. It's not going to inhibit the progress. We're working together on it.
Okay.
This is the court's definitely correct. This is the web situation. We sat down and sort of diagrammed all of the open cases this touches and the open, the unindicted cases that we would need to indict. And I think probably we can get a global recommendation that may include a request to accuse some things instead of indict some things. I honestly think there's no reason to not have that done by the end of the week.
Okay. So why don't we do the same thing, Mr. Bowles, that Ms. Nelson will check in with you next Monday just to see, this has more moving parts than Mr. Campbell. Mr. Campbell's case has a million charges, but is one case. Mr. Jackson has lots of cases, so it may take a little bit longer, but what we'll do is, if you haven't let us know, I'll have Ms. Nelson check in with you on the 17th to see if you think, you know what, this is resolvable, and I, Corey Bowles, will keep it to resolve it. We need 2 more days, or set it down for a plea, and we'll make it happen. Does that work for you, or is that too much?
That works for me, Judge. Is Monday a holiday or not?
Monday is a holiday, so I guess I should say 1/18 will be when people are reaching out to people. Thank you for flagging that.
Okay, all right, sure will, Judge.
So you just got a bonus day to resolve all these cases.
Okay.
Mr. Jackson is here. Would you like to do the same thing as with Mr. Campbell, or have you connected more recently with Mr. Jackson? What's your preference?
I saw Mr. Jackson last night, so I explained to him the situation. I told him that what I am waiting for is an offer, a global offer. So if I get one this week, I'll be back down there to see him. But I did explain to him last night the situation.
Great. And should Mr. Bowles be looking to hear from Mr. Parrish or Ms. Convery, or it'll be one of the two?
It'll come from more likely than not come from me.
Okay. And have you met Mr. Parrish before, Mr. Bowles?
Yes, I have.
Great. So that's likely your point of contact from the state for Mr. Jackson. Be great if we hear from you all, but if we don't, Ms. Nelson will be bugging Mr. Parrish and Mr. Bowles on Tuesday, the 18th.
Okay.
What I'll probably do is let Ms. Nelson know sort of the universe of cases is affects, because it may make sense to kind of do a afternoon or morning. So all case if we get something.
Sure. Yeah. We'll certainly make the time for it if it's going to resolve all that. And web is the right way to describe it. It touches a bunch of different things. So we'll make the time if it's lining up that way. You know, Mr. Jackson may not be interested, and then as long as he appreciates, and I'm sure you've explained it, Mr. Bowles, it will slow things down for him even more, because there'll need to be a new attorney plugging in who will have to relearn everything you've learned about his many situations.
Right.
Okay. Sounds good. So Mr. Jackson can go back. Was that it for you, Mr. Bowles, or did you have anyone else?
That's it for me on today's calendar, Judge.
All right. Thanks for joining us.
Thank you, Judge.
Ms. Rockwell did ping in and said she's got to pop into another court. She said something about Mr. Kimber having open cases as well and wants a global, whole theme for the day is global resolutions.
He does have an open cases, Your Honor.
Okay. All right. Well, she'll be back and we'll talk. It may not be a plea today because she may want to see if you can resolve something else with the crime lab thing, but we'll see. We need her for that. Position 14 is Mr. Warner. Did Mr. Katz make it? Mr. Katz is in front of Judge Glanville right now, so we will hold on that one. But nothing's changed for you, Mr. Abate, on that one?
Yes, Your Honor, nothing's changed.
Okay. Ms. Grant, is Ms. Grant here? Hello, Ms. Grant, how are you? Ms. Beza, my recollection is that you said you could be ready on this, but because of a trial with Judge Ingram, your request was the March 21 date. Is that still true?
That is correct, Your Honor. I'm especially set in front of Judge Ingram February 8th.
Yep. Okay. Ms. Patel, was this one where you were concerned you might not be ready by March 21? I'm just not remembering. I'm not singling you out, but I don't want to misrepresent. We've got Ms. Grant here.
That's correct, Your Honor. I'm missing all the discovery. I just have the initial complaint packet.
Right. And did anything change from, I know it was recently that we all talked about it, but Ms. Beza was going to try to get you the rest of things.
I believe she's working on it.
Okay. Ms. Beza, any update on discovery and the Grant? Ms. Grant, you can take a seat.
Yes, I'm gonna have to meet with Ms. Patel to see what she's specifically missing. I went through the file and see what was served. It looks like discovery has been served, but I'm sure there are things missing. So we're just gonna have to meet next week, or she's gonna send me an email to discuss kind of what is actually missing.
Okay, so it's Monday of this week. Is there a reason why you guys couldn't meet this week?
I'm sorry, today's Monday. Yes, we can meet this week.
Okay, great.
I can reach out to her this week.
All right. I think what I'll do, Ms. Patel, is keep Ms. Grant's case as a possible for March 21, because if what you get from Ms. Beza is an inch of paper and that's it, and there's no video, this or that, that may be something that you conclude, oh, I'm good to go. But if it's sprawling, then certainly I will, as long as you file a written motion so that we're documenting that it's a defense request and not a state request to continue, and you and Ms. Grant have conferred about that, we'll work through that. Okay?
Yes, sir.
Do you need anything from Ms. Grant? Should she stick around?
She should stick around.
Okay. Ms. Grant, Ms. Patel wants to chat with you. When she says it's okay to go, you're good to go. Okay? Do you have any questions for me? No? Okay. All right. Mr. Is it Veet or Vite? I know you're on the call. Is Mr. Deland on the call?
Sorry, I was trying to unmute my thing. He is not, it's Veet, by the way.
Great.
Can you hear me?
I can hear you. I can't see you, but I don't need to see you right away. Do you have an update as to
I didn't
your?
turn my video on.
There he is.
Here we go.
All right. So where's your lawyer?
Mr. Deland is at another court, and he's gonna log on as soon as he is available. Is that a problem? Can we wait a little bit?
This is not a problem. That just means we'll sit tight. I made a note and we are holding for Mr. Deland. And what was relayed to me is that your case ought to be working out today, but we need Mr. Deland for that to happen.
That is true. Yes. Thank you.
All right. So you go back to mute and invisible and we'll rouse you when it's time.
Sounds good.
All right, Eugene Holder, Mr. Holder here.
Good morning, Judge.
Mr. Holder's right there. Hey, Mr. Holder.
How you doing?
And we've got Mr. Russ on the call as well.
Yes, I'm here, Your Honor. Nicole Mormon is first chair on this one. She's lead counsel. She's on another call. I'm not sure if she's available or not.
So my understanding, Mr. Russ, is that Mr. Holder will be entering a plea today. We're not going to be able to do that right away anyway. So if you want to try to track Ms. Mormon down, that's great. And when she is ready, assuming it's a plea, that's just what I had heard, we can do that when we get all the right folks in place. Am I understanding it correctly?
That is not my understanding, Your Honor. I think I just saw Ms. Mormon get off mute.
There she is.
We
Hey,
are not
good morning.
good, Your Honor. We're not prepared to take a plea this morning. We actually don't have all of the discovery yet. I spoke to the state Friday and they were supposed to be getting us the remaining discovery, but as of now, we haven't received it.
So this trial calendar has been published for many weeks. When was it that you let the DA's office know that you felt you were missing some discovery?
We had been working with Ms. Hall and we let Ms. Hall know, I think Mike regarding missing video reports. It was just recently brought to our attention that Ms. Hall is no longer in this courtroom, and the new prosecutor contacted me Friday to discuss the case, and that's when we knew that Ms. Hall was no longer working on this case. But prior to that, we have multiple correspondence between ourselves and Ms. Hall discussing the issues with the missing discovery, and she was supposed to get it to us, and she just never did.
What's an example of something you're missing that you think is making it difficult to figure out how the case should resolve, trial or plea?
The bulk of the case is based on a surveillance footage that that Ms. Hall stated she does have possession of, but we were never given it.
Okay. Ms. Charles, what do you know about discovery and surveillance videos and things like that?
So after speaking with Ms. Mormon, I learned that there was outstanding discovery. And so we spoke on Friday afternoon. I told her I will be looking to track that down and get that to her ASAP.
Okay. Ms. Mormon, I know nothing about the case. So you know a whole lot more than I do, because even a little is a lot more than none. Assuming the surveillance video shows whatever it is the state alleges happens, is this a case that's likely to result in a plea? And I ask not for you to commit to anything, but I need to figure out where to put Mr. Holder's case on this trial calendar, because it's not going to come off the trial calendar. It's either going to work out or it's going to be a trial. So I don't know anything about it.
Yes, Your Honor, we do anticipate a plea. Mr. Holder. I don't know how it just disappeared, but Mr. Holder does have another Fulton County pending case that we would like a global resolution for.
Okay. Is it an indicted case or an unindicted case?
He is not indicted yet.
All right. Let's make a note of that. Okay. So what's a reasonable deadline, Ms. Charles, for you to get this discovery to Ms. Mormon and Mr. Russ?
You know, I can have it to her this week, if not by the end of the day today. If I
Okay.
can go ahead and track that down. I can do
All
that
right.
This week.
So assuming, Ms. Mormon, you got this discovery in the next couple days, how much time would you need to review it and talk with Mr. Holder so that you can figure out, yeah, this is one we should resolve, or based on that video, we want a trial?
We wouldn't need much time, Your Honor. I'd say a week.
Okay. Ms. Charles, of the 3 trial dates we're looking at, February 2, February 16th, and March 21, which can you be ready for?
You know, we could do February 16th or March 21st, either is fine.
All right. Okay. Do you happen to have the CP number of Mr. Holder's other case, Ms. Mormon?
I can look it up. Your
I
Honor.
do, Judge. It's
Okay.
21 CP 202-721.
721. All right. Well, it makes a lot of sense to resolve everything together if we can. And we'll see if we can make that happen. I'm going to ask you, Ms. Mormon, to make Mr. Holder's case a priority for you once you get that discovery. Because if we're going to handle it by way of a plea, that's going to need to happen in advance of February 16th. So folks aren't getting ready for a case that's not going to be tried. But I understand that you obviously need the surveillance video if you're going to be counseling your client to go one direction rather than another direction.
Yes, Your Honor.
The unindicted case is a theft by taking. So it does seem like whatever the situation with that is ought to be resolvable in conjunction with this one. Okay, Ms. Charles, anything else in connection with Mr. Holder?
No, Your Honor.
Ms. Mormon, anything else besides you need discovery?
Nothing further, Your Honor.
All right, Mr. Holder, you are free to go, but stay in touch with your lawyers because we're going to see you either in court for a trial or for a plea, okay?
All right.
Yes,
Sounds
Your Honor.
good.
All right, that gets us to Mr. Pritchett.
May I be excused?
Yes, you may. Mr. Bridges, are you on the
Good
call?
morning, Your Honor.
There he is. Good morning. Mr. Pritchett, had a big revocation in front of Judge Ingram, and so he is working through something else. Tell me what's going on in terms of this case.
Your Honor, Mr. Pritchett insists that I'm not his counsel.
Oh, that's right. I forgot. Right. So, Mr.
But
Pritchett.
I have worked the case. I filed the motions. I did everything, but he still insists I am not the counsel.
Okay, let me see if we have, whoops, that was the wrong button. Mr. Pritchett, 18. Oh, he's not, he's in Department of Corrections custody, so he's not going to be on this call anyway.
Yes, Your Honor.
So the last time, Mr. Bridges, you had contact with Mr. Pritchett, he told you what he told me, which is, first of all, don't call me Max Pritchett, but second, Mr. Bridges is not my lawyer.
Yes, Your Honor.
Okay, so we need to get him back here and work through it. You have on his behalf filed a motion for severance and a Bruton motion, and you
Yes,
are
Your
his attorney of record, so we will litigate those if we need to. If Mr. Pritchett decides that it would be wise not to represent himself, are you available for either the February 16th or the March 21st trial dates?
Your Honor, I would be available.
Great. Please keep those on your calendar. This is a case that has a few people in jail for a long time, and it would be good to move forward with it, assuming we can.
Yes, Your Honor.
All right. Excellent. We'll keep you posted.
All right. Thank you, Your Honor. Have a good day.
You too. Position 19, Mr. Robinson, is represented by Ms. Taylor. Is Ms. Taylor on the call?
I'll reach out to her office and see if I can find her, Judge.
Great, thank you, because we do have Mr. Robinson available at the jail if we need him. All right, position 20, Ms. Kalish and Mr. Zimmerman. He suddenly filled the screen there. Good morning, Mr. Zimmerman.
Good morning, Judge. How are you?
I am well. How are you and your client?
Doing very well today.
Good. Tell me what's going on with this situation. Well, let me tell you so you don't have to, in a large group setting, go into a whole lot of detail. What was relayed to me is that Ms. Kalish likely will not be going to trial. Is that your understanding?
Correct. I had a lengthy conversation with Mr. Parrish on Friday, and that's correct.
Good. Okay. And you and your client would be available for a trial if your client went to trial or participated in a trial, either that February 16th or that March 21st.
Definitely in March, I do know I have a potential leave, the week of the 21st, if my meeting still goes forward because of COVID or not, I don't know.
Yeah.
So I'm trying to work it out.
Okay. Got it. Mr. Parrish, anything we need to discuss at this point with Ms. Kalish? We need to let everyone know if this is a trial and when it's a trial.
That's it, Judge.
No pending motions you're aware of from Mr. Zimmerman?
No, not that I'm aware of.
Okay, Mr. Zimmerman, anything you think needs to be litigated in advance of this case going to trial?
No, Your Honor.
Okay. Mr. Parrish, if Ms. Kalish is not going to trial, do you see a reason why Pritchett and Robinson have to be severed?
I do not, Judge. I think that her being separate from them in regards to her case.
Right. If she's tried separately, resolved separately, whatever happens, then the other two could be tried together.
Yeah, three here, Judge.
Oh, right. We've got a third. Here it comes. Okay, great. How about Ms., is it pronounced Riley? Oh, well, before we jump to that, Mr. Zimmerman, you and Ms. Kalish are free to go. You're welcome to stay on the call. We still need to talk about Mr. Robinson when Ms. Taylor gets on, and we're going to talk about Ms. Riley right now. But insofar as you or your client need to go, you're free to go.
Thank you, Judge. I'll listen on for a few minutes.
Okay.
Good to see you. Happy New Year.
Same. All right, let's pivot to Ms. Riley. do we have Mr. Keller here or Mr. Finling on the call or in court?
Yes, morning, Your Honor. Zach Keller from Miss Riley. She's here on Zoom.
Okay, I need to see Ms. Riley.
I'm right here, sir.
There she is. Great. All right, go dogs. So Mr. Keller here, tell me what the plan is for your client. We are looking at a trial date of either February 16th or March 21. It sounds like the trial will not include Ms. Cavlish, but things can change.
Yeah, I just need to reach out and speak with Mr. Parrish to see whether or not we're going to be going forward. I have a specially set federal trial starting on March 9th, so I would not be available for that March date.
How long is this federal trial?
3 to 4 weeks.
Okay, specially set where?
It's with Judge Jones here in the Northern District.
Okay. And
So U.S. versus Mitzi Biggers.
oh, you're on that, huh?
Yes.
Okay.
So
Well,
that just got reset to the March date.
got it. So we would need to do the February 16th. That helps us settle on a date. Good to know. All right. So what I'm going to do is put Ms. Riley down as ready for trial February 16th. If Ms. Riley is going to resolve her case short of trial, that would need to happen before February 16th, unless it's a straight up plea to the indictment. I guess the third option would be if Ms. Riley is somehow going to be in a situation like Ms. Kalish, where maybe her case is not resolved up front, but Ms. Riley, is not going to trial alongside Robinson and Pritchett. That would work too, but you and Mr. Parrish need to put your heads together on that one and figure it out. If only because I need to plan on how we would handle a 3-defendant trial in the courtroom. We can pull off 2. 3 is a little complicated with the social distancing, but we'll make it happen if we need to.
All right, sounds good. And I'll reach out and me and Mr. Parrish will talk as soon as possible.
Hold on one sec. Yes, sir.
Keller, I just put my cell, my personal cell and my email in there, so feel free to contact me whenever you get the chance.
Got it.
Thank you, Doug.
Mr. Keller here, who else, if anyone else, is defending the case in front of Judge Jones?
Myself, Mr. Finley, and Ms. Goldberg.
Okay, so it's sort of the same trial team as we've got for Ms. Riley.
Yes, well, I'll be lead up for Ms. Riley's case.
Okay, great. All right, well, that's the info I needed. Ms. Riley, you have any questions for me or are you good?
No, sir. Thank you.
All right, you're welcome. You are free to go.
Thank you, Judge. Have a good day.
All right.
That's my last case. I'm here in Judge Richardson's court. I can come back and see if Ms. Taylor shows up.
Yeah, please be available for Ms. Taylor's appearance because we do have Mr. Robinson available on Zoom.
I will, Judge. I'll keep you on Zoom and I'll come on back up either way afterwards.
Great, thank you. All right. That gets us to Mr. Lee. Let me get Mr. Lee on the screen because I know we've got Mr. Steele on the call. I don't know if we also have Mr. Florio. Let's see, Mr. Lee.
Yes, sir, Your Honor. Good morning.
Hey, both of you are here. Great. Let me see if 5 North. Mr. Lee, can you hear me?
Yes, sir.
There he is. Let me pin that. Can you say something one more time?
I can hear you, Your Honor. I can hear you.
Good. No, I know you can hear me. I just need to get you away. Do it this way. There we go. All right. Just want to make sure everyone can see you. Mr. Lee, we need to talk about scheduling your trial. Ms. Convery represents the state, I think, still in this. And you've got Mr. Florio and Mr. Steele as your attorneys. and we need to figure out a date when we can try it. Ms. Convery gamely tried to explain to me Mr. Steele's schedule, but she gave up. But fortunately, we've got Mr. Steele here, so he can explain it. Tell me, Mr. Steele, of the dates we've been talking about, what works for you and what doesn't, and I can see what we can line up.
Good morning, Your Honor. Good morning, everyone. It's good to see everyone. Mr. Lee. Your Honor, February 2, I start a trial. I call it a trial. I'm representing a very fine lawyer before the state bar. It's before the special master. That goes out Tuesday, the 1st of February. It's supposed to last 2 or 3 days. So February 2, and that's specially set. February 2, I believe I will not be available.
Tell me your understanding, sorry to interrupt, but how does a specially set criminal trial and a bar proceeding with a special master, how does that go in terms of what I've never had those two collide before, so I'm not in a position to say, oh, that's fascinating, but they need to move that one because we've got a young man who's been in jail for almost 2 years, and so his trial would take precedence.
I mean, that's fine with me. I don't know. I just know it starts the 1st. So we'll be in the midst of the trial. And I always thought that if you are beginning something, if a lawyer begins something, then they are attached. That's what I believe to be the rule. I cannot tell you. I have to look it up, Your Honor, research.
Okay. No, I think you're right. But in my experience, that has been if, for example, there was a different trial as opposed to this type of proceeding. I just don't know if this type of proceeding even hits the radar of criminal things, or if a criminal matter would cause an earlier commencing non-criminal matter to have to move to the side. I don't know, and I'm not trying to make life difficult for you, or in particular, your client in that matter, but I may look into that a little bit as well. Assume February 2 is not good because of that. What about February 16?
And I know you advised before that we pick a jury and then we don't start the actual evidence until a time later. Are we going to pick a jury and let's roll into the trial immediately?
So for February 16, that's a Wednesday. It looks like we plan on starting the trial the following week. In other words, we'd pick the jury on the 16th, but not then that Thursday and Friday have jurors come in. We can be flexible about that. I just noticed that Monday the 21st is a holiday. And so we'd be picking a jury and then not seeing them now for almost 6 days. So it may make sense to pick the jury and then get a couple days. I don't know how long this case would take to present. But unfortunately, our jury selection day is Wednesday the 16th. And tentatively, we plan to then start openings that next week, which I thought would be Monday the 21st. It says President's Day. I don't know if we still do President's Day in Fulton County. We don't? Oh, then it's easy. So we'd start Monday the 21st. I'm going to take that off my calendar.
Your Honor, on Monday the 21st, I have been specially set by the Honorable Cobb County Superior Court Judge Harris, Ann Harris, in State of Georgia versus Mr. Acosta, ACOSTA.
And that's a special setting, older case, newer case.
It's a 2018 case.
So it's specially set and it's older.
It could be. I have to check the indictment, but I'm going by my memory, but I feel comfortable telling you it's a 2018 case.
Okay.
But I have to, please let me check that if you don't.
Okay, that's fine. I can talk with Judge Harris about it too. I don't know if she specially set 6 cases that day or 1 or what. So we can work through that. All right. How about March 21?
March 21. When would that trial actually start, Your Honor? Is that just going?
Whatever day will trump any conflict you have is when it will start.
Okay.
That's a Monday. So we pick the jury Monday, and that's when, I mean, technically, so we're clear about this, your trial with Mr. Lee starts on February 16th. We pick a jury, the trial started. If I need to swear the jury in that day so that it started to say, sorry, Judge Harris, he's already in trial, I could do that. I'm not interested in making these kind of waves. I am interested in getting poor Mr. Lee's case tried, and we've continued it at defense request. I mean, I may be running out of fingers soon on this one. So, but to answer your question, March 21 is a Monday. We pick a jury that day, and it's like the good old days. The next day, which is a Tuesday, the jury that was selected will be back, and we're moving along.
So I'm available. If it matters to the court, I'm specially set before the Honorable Judge Ross in Northern District of Georgia in United States versus Mr. Benny DeShazer, but that doesn't start till March 28th, which is the following Monday.
Okay. So the only of the 3 dates for which you at this point don't have a conflict is March 21. February 16th is a little funky because you don't have a conflict for the 16th, but that following week, you've got a case in Cobb that's specially set.
True. And, I'm with the court. So you tell me, I'm ready for Mr. Lee, and we'd like to try it as well. And I appreciate what this honorable court just said. And so does Mr. Lee and Mr. Florio. So we're ready whenever you can reach us.
Right. We need you. Yeah. And you are in demand in other places. And then February 2, the conflict would be the state bar proceeding.
Right. When does that trial actually start? And I understand once the jury's selected, it starts, but when would the evidence, I guess, opening statements begin?
Right now we have it going the next day, starting on the 3rd. Jurors would the jury that was selected would come on in.
Okay.
So we would just move right along. But I'm looking at the calendar to see if there's any reason why and that's how we'd want to do it. We'd want to keep it that way, where we pick the jury on the 2nd, and then on the 3rd, we start with opening statements. Mr. Florio, what about you? You available those dates?
Judge, I have conflicts as dates, but nothing that would trump, Your Honor. So I would be available any of those 3 dates.
Okay. And Mr. Steele, I'll make sure I'm remembering correctly. The case in Cobb County with Judge Harris, that's one where you are specially set to start on the 21st.
Right. So just to be complete, when you speak with the Honorable Judge Harris, we are specially set to start on the 21st, like you just said.
Got it.
There were 4 defendants because of Bruton legal matters. The judge severed all 4 accused, and therefore the first person being tried February 7th, specially set. I am being tried, or excuse me, my client and I are being tried February 21, and then the other 2 are coming behind us. If the first case set for February 7th has some issue with a health issue, or I don't think they said it's not going to resolve, but a health issue or it resolves, then I am then, if you look at the Honorable Judge Harris's order that she told me she would either do or did, I am then specially set as the backup on February 7th, but I'm told to not make any plans except to be with her on February 21. That's exactly what was said to me.
Got it. Okay. I appreciate that. Okay. Ms. Convery, anything you want to add to this? You've said you're ready to try the case. Are there conflicts you're aware of?
So for what it's worth, and it doesn't, my conflicts don't matter as much, but for what it's worth, my preference would be that 16th date on the March week. I hope to have a personal leave that week, but it just doesn't matter. It's not a situation where the state won't be ready because of that. We and I will be ready to try this case, whatever the court calls it. But as far as preferences go, that matters in this conversation. The 16th is the best week.
Okay. Is February too soon? If the state bar situation is movable, that's not too soon? Okay. All right. Got it. Mr. Lee, you've listened very patiently. You have any questions for me? Not about the facts of your case, that's for you and your lawyers, but about what we've been talking about?
No, Your Honor.
You're ready to go?
Yes, sir.
Okay. All right. So, Mr. Steele, I'm gonna think through a little bit about your different conflicts, and we'll figure out the cleanest date for you. It sounds like is March 21. That's further away. I just need to see what other cases are ready when. And I appreciate you can only be in one place at one time. So we will work through this in a way that strikes that balance.
And thank you, Your Honor. And we're ready, as we just announced. And Your Honor, if it matters to you, in that state bar matter, the special master is the Honorable Pat Head, if that matters. If you're going to the judges or the special masters, he's the person who set that February 1 date.
Got it. Okay. Thank you so much.
Thank you. May we be excused?
You may. And Mr. Lee, you are free to leave booth 1 on the 5th floor, North Tower. Thanks for your time.
And Your Honor,
yeah, hold on. Before anyone goes, yes.
do you do the announcement later today or tomorrow and tell us, what we...
I will try to. It's going to take a little work figuring out your situation. You are more complicated than the average bear. So I had to poke around a little bit there. But soon, Ms. Nelson will get an email out saying, these are the cases that need to report on February 2, ready to go forward with the jury trial. These are the ones on the 16th, et cetera.
Thank you so much, sir.
Okay.
Thank
Bye-bye.
you, Mr.
Love you, Josiah.
Love to.
Love you.
Okay. Kayla Johnson is a co-defendant in that case. There's Ms. Johnson. Hello, Ms. Johnson. And Mr. Ensline, how are you?
Good, Your Honor. How are you?
I am well. My understanding is that Ms. Johnson will not be going to trial at the same time as Mr. Lee. If she's going to trial, it would be after Mr. Lee is tried. Is that correct?
That is our understanding, Your Honor.
Okay, and you will have Ms. Johnson available on whichever date the trial occurs.
I have no conflicts for the February or March calendars. We'll be ready at the court's pleasure.
Okay, well, it'll be, we'll see how it plays out, but I just need to make sure there wasn't one of the dates we talked about where you knew, I'm out of the country for that full week surrounding that, but you're good.
No, guys.
Okay, great. Ms. Convery, anything on Ms. Johnson's case?
No, I need to check my seating to make sure that I formalize this by immunizing Ms. Johnson. I can't remember if I said or not, but I spoke to Mr. Ensign about it. So just as the court call that come through, I don't want you to think that was like a new situation.
Okay, I can look right now. I mean, would it be, you think it's already in the docket?
Yeah, this would be in the docket. I haven't, I'll formalize that this afternoon.
How long ago would you have done it? Yeah, you haven't done it because there's since 21 January. So a year ago, nothing. I mean, you've got some USB drives out, but that's it. So need to do that. All right. Great. If Ms. Convery doesn't need to talk to you, Mr. Ensline, you and your client are free to go.
Thank you, Your Honor. And I'll be in the building for the rest of the morning. So if anything comes up, I'm here.
We'll track you down.
Thank
All
you.
right. Thank you. Tomar Richardson. There he is. Good morning, sir. Ms. Patel, we had talked about how this might be a plea. Still the case? You need to talk with Mr. Richardson?
I do need to talk to Mr. Richardson and still working on it with the state. There is the CP case that is outstanding.
Do you have that number?
21 CP 197872.
21 CP 197872. Got it. Okay. So Mr. Richardson, you should sit tight. Ms. Patel needs to talk with you, and I don't want Mr. Richardson leave until we as a group talk one more time about his case. Great. All right. Landon Christopher.
Judge, he actually is on Zoom.
Oh, that's right. I've seen the name on there. Mr. Christopher, can you come alive for us?
Can you hear me, sir?
Now I can. Yes, sir. Good morning.
Good morning. Good morning, Your Honor.
So Ms. Wood, I had heard that this was going to resolve today. It's still happening, not or maybe not today, that it was going to resolve.
If you remember, at pre-trial conference, I was having issues establishing contact with Mr. Christopher. The hope was that he would come in today, we would sit down, go over the videos from the state and discuss the resolution with Ms. Charles. He reached out to me this morning. He was outside the courthouse, but he's waiting on a COVID result and he's got symptoms, so I asked him not to come inside.
Good.
That is why he's zooming in.
Good.
I don't know if it's resolved. That I'm showing this video.
Yep.
But I do think we can resolve this short of trial. I just don't have the resolution ready.
Understood. And you and Mr. Christopher probably shouldn't get real close watching videos for a little bit too.
Yes.
Mr. Christopher, I hope you end up being okay, but you should keep your distance from folks for right now. I think what we'll do is handle this like Mr. Bowles's 2 cases. And next Tuesday, the 18th, Ms. Nelson is going to bug Ms. Wood and Ms. Charles. If she hasn't already heard, here's what's going on. You have everything you need. Is that correct, Ms. Wood?
Yes, Judge.
You need time to safely interact with Mr. Christopher so he can watch some of this stuff. You can advise him as to what you think he ought to do. Do you also have, along with the discovery you want to share with him, an offer from the state?
We don't have an offer yet. I was going to speak with her after the call about that.
Okay, but you've got what you need to meet with Mr. Christopher, to share with him the videos, and then you and Ms. Charles will engage in negotiations.
Yes, Judge.
All right, so we'll say update to Ms. Nelson by 1/18. Okay. Do you have good contact information for Mr. Christopher now?
Now I do, Judge.
And does he have your contact information?
Yes, Judge.
All right, Mr. Christopher, don't
sir.
change your phone number without telling your lawyer, okay?
Yes, sir.
All right, go get tested and she'll be in touch with you.
All right. Thank you, Your Honor.
All right, bye-bye. Cortez Griffin. There he is. I'm doing okay. How are you? Ms. Patel, this is a case where the alleged victim is a defendant in another case, and we don't have that case, or we do have it also?
We don't have it yet because it hasn't been indicted.
Unindicted, okay. And the conflict defender handles that matter, not your
Yes,
office.
Your Honor.
Okay, and so.
Your Honor, I'm sorry, Gina Bernard here on behalf of, in reference to that case.
Yes, ma'am.
If I can get Ms. Patel's contact information, like a cell phone, I can text her. Please, can you put that in the chat and I can text you, Ms. Patel?
I will, Ms. Bernard. Thank you.
Thank you.
Great. And that's so then either Ms. Patel, you can talk to Ms. Bernard's client, or Ms. Bernard can mediate that process, assuming Ms. Bernard's client wants to talk to you. Was your thought that, well, how do you envision this case proceeding since it's on a trial calendar?
I expect it to work out. I don't anticipate it being a trial.
What do you need to do besides talk to Ms. Bernard's client?
I believe that the state has served everything. It's just body cam and a 911 call. If it doesn't resolve, I think that it would be a case that we could try on the 2nd.
Okay. Ms. Beza, tell me your thoughts about how you envision Mr. Griffin's case resolving and when you could try it.
I did pull the victim's case last week, and I've been in contact with Ms. Bernard. We're going to be speaking this afternoon. I believe it can be resolved. It'll be a very short trial. So February, again, I'm specially set in front of Judge Ingram February 8th, but I believe we could finish it the week of February 2nd.
Yay, a case for February 2. Okay. Well, that'll be the plan if it's not resolved, unless, Ms. Patel, you learn, because of this complication of your ability to talk to Ms. Bernard's client, if something gets in the way, let Ms. Nelson know sooner rather than later, but we'll put this there, which just means if it's going to resolve short of trial, it needs to be before February 2, and we'll make everyone available. And in theory, Ms. Bernard, if the way Mr. Griffin's case is resolving, would also involve your client's case resolving, and the state's willing to accuse it, I'm happy resolving that as well so that it's not left hanging out there. But I leave that to you, Ms. Bernard.
Okay, thank you.
Sure. Okay. Ms. Patel, anything else on Mr. Griffin's case?
No, Your Honor.
Do you want him to stick around so you can talk to him?
I've spoken to him. He can leave unless he has any questions.
Okay. Ms. Beza, anything else on Mr. Griffin's case?
Not from the state, Your Honor.
Okay. Mr. Griffin, any questions?
No, sir.
All right. We'll see you.
All right, thank you.
Position 27, Mr. Gomez Ignacio. You are here. Mr. Do we say Gomez Ignacio? How do you want me to say it? Hold on one second. Mr. Gomez, your lawyer is ill and cannot be here today. It was important that you were here, but you are going to be able to go in 1 minute because we need to track your lawyer down. Ms. Patel, Siri Patel, are you on the call? Nope.
Judge, she was in another courtroom, was gonna report back.
Okay, then Mr. Gomez, I need you to take a seat. We got to wait for the prosecutor to come back, but you'll be able to go soon, okay? Thank you. Carolyn Hill.
Good morning, Judge. Ray Giudice for Ms. Hill, who is present.
Good morning, Your Honor. Jill Hollander for the state.
Hello, and now I just need to see Ms. Hill.
She's there.
She was here.
She's here. I can see her.
Okay, she should say something, then
Ms.
she'll
Hill, say something.
appear big on the screen.
She's muted.
Ms. Hill, unmute your sound.
Okay, I'm here. Thank you.
There we go. Thank you.
There she is. All right, Ms. Hill, thank you for joining us. So, Mr. Giudice, let me tell you what I heard when I was just asking scheduling questions of Mr. Malkin. He said there needed to be some paper exchange still on this one, but that he thought this was likely a plea. I'm gonna let you take it from there, and then obviously we'll hear from Ms. Hollander to get the final perspective from the state.
Your Honor, this case is more likely to be a plea than a trial. We have exchanged discovery. There's no outstanding problems there. We are providing Mr. Malcolm various financial documents regarding my client's ability to pay restitution for the alleged theft. And that's what we're working on. We have some documents either that have just been provided to him or just about to be provided to him. And I think neither of us would have any problem, and Ms. Hollander, to perhaps putting this on the February 16th calendar, which gives us right at 5 weeks to get these final matters resolved.
Okay. Do you need anything from the state, or currently the flow is from you to the prosecutor's office trying to educate them on Ms. Hill's ability to pay?
That's accurately stated, Your Honor, with the last caveat is that the victim, who is Ms. Hill's brother, has to get with Mr. Malcolm to approve whatever, or at least give his input as to the final plea negotiations, which would include the restitution payment plan.
And just ballpark, are we talking about hundreds of dollars, millions of dollars? What is the order of magnitude?
The allegation is somewhere north of $100,000.
Okay.
And less south of $300,000.
Okay.
That would be obviously part of if the matter had to be litigated, that would obviously be part of the state's presentation of what was used permissibly versus impermissibly.
Okay.
So we concede it's a large sum of money.
Got it. Okay. So there are more moving parts than if it was a $10,000 situation.
That's correct, Judge.
All right. Ms. Hollander, anything you want to share from the DA's office side?
No, I think he's pretty much well summed it up. We did receive a large number of banking documents very late on Friday afternoon. We're going to start going through those this week, see if maybe there's some other stuff that we might ask for. It does sound like the sole issue at this point is the amount of restitution that will be requested. I anticipate it's probably going to take us at least 10 days to get a handle on these banking documents. We'll circle back with defense after that. And then if we can't reach a restitution number, we would make the court aware, but I don't think that this will be a complicated matter.
Okay.
Judge, very briefly, I agree with Ms. Hollander that issue number one is the amount of restitution, but equally as important is the monthly or the repayment plan, as my client is on a fixed income. So those are the confines we're working within, but we are working on it in a very good faith.
Okay. Yeah, I took amount to mean here's the total and here's the way in which, almost like an installment contract, it would be expected to be paid back. And I appreciate that that's going to involve some back and forth. So as much as I'd like to say you better be ready by February 2, it sounds like February 16th is the more prudent deadline to say, hey, if you haven't resolved it, come on in and try it then. Is that your sense, Mr. Giudice?
I agree with that, Judge. However, I would also say that if we're starting to approach the 16th, and and I've worked with Mr. Malcolm for many, many years, and Ms. Hollander as well, then we would notify the court sooner rather than the morning of the 16th as to what our status is or how close we are.
Okay, well, I would handle the February 2nd date that way. If we're putting this down for February 16th, that'll be the day we pick the jury, not the day we move it from there, because the people are still negotiating. So I'm happy to put it on February 2 as a stretch goal, but if we're running up against that date, you let me know. But I'll let you know. That's over a month from now. And if what is left is haggling back and forth on the scope of restitution and one's ability to pay, I'm very comfortable saying that is more than enough time to work that out. And if by February 16th you haven't, then it is time for a jury to work it out. So if you'd prefer to have a flexible date of February 2 backed up by February 16th, I'm fine doing that. But I want both sides to understand that February 16th would be the trial date, not the, hey, are we doing okay on that date?
Understood, Judge. I still would prefer to go on to the 16th. Again, we're working diligently, but that gives us a solid 5 weeks.
Okay, got it.
It is possible that we're going to need some additional records, which would be at the behest of banking that does not necessarily move at our speed.
Understood. Okay, well, you'll want to get those requests in soon.
Yes.
Ms. Hill, do you have any questions of me, or you think you understand what's happening?
I understand. Thank you.
Okay. Well, Mr. Giudice, thank you for joining us. Ms. Hollander as well. I'm glad Mr. Malcolm was able to go see his mother. And we'll put this down for February 16th.
Thank you, Judge. May I be
Thank you.
excused?
May I be excused?
Yep.
All right.
Thank you.
Bye.
Great. 29 has been resolved, which gets us to 30. Ms. Carlin. I think I had seen Ms. Carlin in court. There she is.
There's been a plea worked out, but I think we asked for a plea date. It's having spoken with the states.
Plea date. What's wrong with January 10th?
Nothing wrong.
Okay. What would be a better day for you, Mr. Rao?
Is it possible anytime next week you set down for the date?
It is. And that's what we do that day, or we'll see if we're pleading that day.
And have an offer, explain to her that's what we anticipate coming, that it's going to include.
Okay. Tell me, the answer is yes, if you can explain why a date next week is better than today.
Judge, I've been trying to get in touch with the victim's mother in this case.
Okay.
The
That's fine. If it's victim related and not, well, but I need to have a supervisor approve this or that. You're in a position to work the case out. You just want to make sure you've taken care of the things you ought to. Yes, next week I was supposed to be in wonderful Athens, Georgia, being re-educated as a judge, but they decided that that should not be in person. So I have all this found time. We'll work with your schedules together to make sure that it is a time. I'm fine with virtual. I don't know what the outcome of the plea is, though. Virtual doesn't make sense if someone's going into custody. I'm also fine with in person. As you can see, we have a full courtroom. You and your client need to be comfortable with the format. So if Ms. Carlin wants you by her side, wherever that is, whether it's in your office or here in court, you need to make sure it works out that way. But just know that given the numbers, we are letting folks appear remotely if that's their preference and someone's not going into custody. So you guys work it out how you want with Ms. Nelson. The date and time we set, I will be right here. You're welcome. There'll be a Zoom link too, so you can patch in as long as you and your client have agreed that that's okay. Okay? Was that part of your renegotiation of your contract, huh?
Just, you know, my son has surgery Thursday morning, so if I could just let
You're talking about next week? Yeah, so let's just, since you're here, I don't want to let everyone go and then I promise something that I can't deliver. So next week is the week of the 17th. The 17th is a holiday. The 18th, we could do. No, you're saying Thursday is bad for you.
Yeah, next Thursday, the 13th.
So that's this Thursday is the 13th.
Oh, then I'm out of my mind. I'm good. Sorry.
So you're good next week. All right. So I can I'm going to, yeah, no. So you better not miss it. 3 days from now, your son's getting surgery, not 10 days from now. Okay. I hope he's going to be okay. So Ms. Nelson will reach out to Mr. Rao and to, not to you directly, Ms. Callis, but you'll need to be here and we'll make it happen.
Yes, sir.
Okay.
Thank you, Judge.
All right, Mr. Rao, do you need either of them to stick around? You're good? Okay, thanks for being here. Ms. Carlin. And Ms. Carlin's on the calendar twice, doesn't need to be here twice. Just, I think, yes, you only need to be here once in case. All right, we're almost through the calendar one time and we'll circle back. Mr. Goolsby. Yes, I'm sorry. Yes, you may. I didn't mean to leave you hanging right there. Ms. Primovic, do we need to, Mr. Goolsby is available. We can get him in a booth. Do we need to do that? Are you going to let him know? I know that we're looking at one of two dates, the 16th or the 21st for his case.
Your Honor, we don't need him in a booth. I'll go and see him.
Okay. Great. Mr. Abate, any change on that one? Other than you'd prefer the 21st and Ms. Primovic would prefer the 16th. All right, I got it. Excellent. Thank you.
Judge.
Mr. Hodge, same deal. We can get him in a booth if you need him, Ms. Primovic. You are his lawyer as well, and you'd prefer the 21st over the 16th on Hodges.
Correct. And I'm in need of a witness update.
In Hodges?
Yeah, I don't have any. I got everything from Goolsby, from Mr. Abate last week, but I didn't get anything from Mr. Hodge or didn't see anything filed this weekend. So whoever has that.
Okay, I think that's Ms. Love. I didn't know there was a witness update. This is the case, if I'm remembering correctly, an important witness is in Illinois somewhere.
Correct. I do not have that updated number.
Okay.
Call her. That's all. No biggie.
Got it. So it's a phone number for the eyewitness identifier who is now in another state. That's what you're trying to do.
Correct. And I asked if there was any more thing from the fingerprints last week on our status, and Ms. Love didn't say there was. So that's how that goes.
Mr. Abate, if you would pass on to Ms. Love the need to get that phone number to Ms. Primovic, that would be great.
Yes, sir. And Ms. Primovic, do you have a witness list?
No.
Okay, I'll work on getting that as well.
Thank you, sir.
All right, fair request. If that is not forthcoming, please let Ms. Nelson know so we can try to dislodge that.
Thank you, sir. Thank you, Mr. Abate.
All right, we already talked about position 33, which was Ms. Boyd. And then we get to our one supplemental case, which is Mr. Mitchell. Mr. Mitchell, there he is. How you doing, Mr. Mitchell? Good to see you. So Ms. Patel, we had talked a little bit about scheduling this and you connecting with Mr. Mitchell. Do you have any updates? Do you need Mr. Mitchell to sit tight and then you guys talk and you can give me an update?
Yes, Your Honor.
Would that be better?
Yes, Your Honor.
Okay. So Mr. Mitchell, you and Ms. Patel need to chat a little bit before you can go. I need to hear back from her and you before I can say, here's when we'll try to set this down for trial, okay? Thanks. All right, so if we circle back, Mr. Drain is here now. Mr. Robinson, you still on the call?
I am, Your Honor.
Great. And Mr. Whitenauer, you still with us?
Yes, Judge.
Let's talk about Mr. Drain's situation. You had filed a motion to revoke bond in Mr. Drain's case.
Yes.
Mr. Robinson, had you received that motion?
I have received the motion. I haven't received anything in support of the allegation, but I have received the motion.
Got it. Good, because it was e-filed. Is that something, Mr. Whitenauer, you were hoping we would cover today?
Yes, Judge. Ms. Nelson sent out an email to me and defense counsel advising that that motion be heard today. I did speak with defense counsel last week. He advised he hadn't received that email. I then forwarded it to him. It appears that perhaps a number was left off the initial email with that announcement. So yes, we were hoping that would be heard today.
Okay. Mr. Robinson, apart from your observation that you don't have substance behind the allegation, any reason why we can't go forward with the bond hearing today?
No, Your Honor. Would it be the court's intent to have an evidentiary hearing? There would be some things I would need to forward to the court if there's a testifying witness.
Okay. I don't know how it's going to play out, but I might as well start the dialogue on the bond hearing. And we do need to set this down. I think we already have a date for a 413 hearing in connection with, I think these are all connected. The basis for the bond revocation is, I think, also the 413 evidence. Is that correct, Mr. Whitenauer?
Yes.
Okay. Why don't we start the bond discussion today, and we'll see if it makes sense to create a framework, but then it would be at the 413 hearing that we would get more information, or I'm happy to work it either way, other than based on the allegations, I think it's important to at least start that discussion. So, Mr. Drain, I need you to come sit at defense counsel table so that Mr. Robinson can see you and you can see him. Ms. Wood and Ms. Patel are going to move in just a sec. And did Mr. Rooks make it? He is here. Okay. Mr. Rooks is here. Mr. Korn, anything that you need to talk about now that Mr. Rooks is here? We've got this for February 2 as a likely trial.
That's my understanding, Judge. I don't imagine anything's changed about that.
Okay. Ms. Hilton delivered a nonverbal message that maybe February 2 wasn't the date she was thinking of.
I didn't see that.
No, but I did.
No, February 16th is fine. The only thing that we may need to do is something I think could have a pre-trial, Your Honor, is a potential 807 motion, just for some hearsay speech. I think that's something that could happen.
We could fit that in so that there's no surprises on that front. But you think you could have your witnesses, I mean, again, we'll get the email out soon saying here's the order, but if Mr. Rooks's case were spotlighted for February 2, you think that's doable? Great. Okay. Mr. Rooks, do you have any questions about scheduling? I mean, Mr. Korn is your point person on that, and you know how to reach him, and he knows how to reach you. You got any questions about what we're doing? Okay, Mr. Korn, do you need Mr. Rooks to reach out to you right now, or is he good to go?
He's good to go. We'll talk soon.
Sounds good. Thank you, Mr. Rooks, for making it. Sorry you had technical difficulties. We will see you back here soon for your trial.
Thank you, Judge. May I be excused as well?
Yes, sir. And Ms. Hilton, you're welcome to stay, but I think this is your only case.
Yes, Your Honor, but finish the email and then I'll.
All right, thanks. All right, let's get back to Mr. Drain. Yeah, and if you get an update on him, let me know. Mr. Williams is here, I know. Mr. Melnick is here now?
Here.
There he is. Okay. So why don't I think we can knock out a couple quick updates. It'd be good to take care of Mr. Williams too, because he gets bad feedback. So let's talk about Mr. Williams. Mr. Drain, you're in a good spot. Sit tight. Mute your phone, Mr. Williams, and I'll tell you when to unmute. All right, Mr. Melnick, tell me what the plan is for Mr. Williams. 2 of his co-defendants were tried, found guilty of aggravated assault, sentenced to some time in custody. And we've got Mr. Williams as, is he the last person standing in this case? He is.
I believe so.
So, and Mr. Abate has said if it needs to be a trial, he's ready to go on February 2.
Well, Your Honor, I will be glad to speak with Mr. Abate about the case, but for now, the announcement is ready for trial.
Okay.
Your Honor, I do have 2 things to take up with you.
Me?
Yeah, well, I mean, on this case.
Okay.
I will need to have Mr. Blige produced as a witness for the defense. And he was sentenced under first offender, so I'm not able to find him on the Department of Corrections website. So I can present a motion and an order to you just a little bit later today. But he will be tested. I've spoken with his attorney, Ms. Fegan, and he's going to be testifying on Mr. Williams' behalf.
I'm just looking something up. So that's annoying. So I can't open his file.
Because it's sealed under first offender.
It is. I get that, but the clerk's office has been directed to not seal it for the judge who sentenced the person or probation, because in theory, Mr. Blige could get out and be on parole or probation, and they need to file something in it. So it needs to not be sealed for a few people. And I happen to be one of them, but I can't get in his file. That's not your problem. That's a clerk.
Judge, do you want me to send you the sentence?
No, I'm good. I need to engage the clerk's office on that. Thank you.
All righty. Mm-hmm.
Okay. Sorry about that. All right. So that's one thing, is that you need Mr. Blige. What was the other thing?
Your Honor, just has to do with Mr. Williams' bond conditions. He currently has a curfew of 7:00 p.m. and he's gainfully employed, Your Honor. He's actually working in construction, painting houses. And he wanted to know if I could present a motion and an order to extend that until 10:00 p.m.
And how does painting houses keep him out past, let's say, 8 p.m. when it gets dark at 6?
Mr. Williams, that might be a question for you if your phone is working. It seems your phone is.
Yes, Your Honor. Due to the fact I pay a subcontract, I don't get paid by the hour. So I get paid a job. So I work for apartment complex. So we have several units at us. So as far as me working like hourly, that's not painting moves, you know. So as far as we're paying, we get by the hour. So I can't like go to work and get off at 7 and expect to get paid. You see what I'm saying? Because I'm assigned to so many units as possible, as well as me being a delivery driver for my mom for our company, for the family company that we have. So that's real hard with battling with.
All right, so I'm less worried about your job with your mom because she can be flexible about your hours. Tell me about this painting thing. Why would you need to be somewhere until 9 o'clock?
Why would you need to be somewhere until 9 o'clock? I work for apartment. I get paid. I do subcontract work. I don't get paid. Painters don't get paid hourly. Painters get paid by the job. So if I'm assigned to complete a job by tomorrow within 2 days, I'm on that job by 2 days. So basically, like the subcontract is forfeit. Like I won't get paid, and then I'll get lack of funds as well. My living stability.
Okay. All right, Mr. Melnick. So you need Mr. Blige produced and you want to have Mr. Williams's bond modified. I'm going to figure out how quickly we can get Mr. Blige here. I'm not inclined to change anything about Mr. Williams's bond until we resolve his case, which we can do maybe as early as February 2, if he really wants to go to trial, based on the videos we've seen. So, but if we cannot get Mr. Blige here in time, then we'd have to do February 16th. And the longer we push this out, the more likely I would be willing to modify Mr. Williams's bond. But that's where we are right now. Mr. Abate, anything you would need to get ready for trial that I need to get in the middle of?
No, Your Honor, I just may need to get some interstate compact orders signed ASAP to the court, but nothing other than that.
Okay, well, both of you, please, Melnick and Abate, if you're bumping up against that February 2 date for logistical reasons, i.e. we can't get a witness here, please let Ms. Nelson know. We'll figure out the Blige thing real quickly and go from there. Mr. Melnick, anything else on Mr. Williams?
Not at this time, Judge.
Okay. Well, we'll pencil it in for February 2, assuming we can get all the witnesses here that we need. And if not, February 16th. Thank you.
Thank you, Judge.
All right.
Excuse. No.
Done. All right. Mr. Katz.
How are you doing?
I am well. Let me find. Yeah, your case, Warner 14. South. Hey, Mr. Warner, are you there?
Yeah, hey, how you doing? Good morning.
Good morning. Let me get you big on the screen here. There he is. All right, we're gonna talk about your case real briefly and then get you on your way. So Mr. Katz, Mr. Abate told me he is able to be ready on this either February 16th or March 21. Those are 2 of the 3 trial dates we've got for this calendar. Tell me about your schedule.
Sure. When we're supposed to start a trial on the 7th in Meriwether County on an over traffic case.
February 7th or March 7th?
February 7th.
Okay.
And then sometimes we're talking about pushing these cases to like February 22nd, although I know that wouldn't date. I started murder trial early in county case. This is the first time I'm hearing that there's a new prosecutor in the case. I talked to Mr. Rao this morning while we were in Judge Landell's calendar. And I had reached out and I need to get with DA now because we had sent him an email back in November indicating there were some videos which are not working. And I never got a response back, but now if I can reach out to you, I should hear about that. But it sounds like March 21st could be my best thing.
Okay, and that's far enough out that if we need to get you, if the state needs to get you videos you can play, you'd have plenty of time, you to watch them, and then for you and Mr. Warner to connect and watch them. Mr. Abate, this was originally, I know originally it was Mr. Pinions, but then I guess it was Rao, and now it's you? Okay, so you can connect with Mr. Katz about whatever discovery he might be talking about? Okay. All right. So it sounds like March 21 is the better of the 2 days. February 16th falls between these two, and it might be that we nudge that Irwin or Merriweather, whichever the second one was, out of the way. But we'll see. I am anxious, as I'm sure Mr. Warner is, to get him into court and resolve this. Whatever a jury's going to say about the case, it's not getting newer, and he's not getting younger sitting there on the 6 South. Mr.
The murder case that I have in Irwin is an older case, and it is already specialist.
Is that the one that is before, or the one that is?
Well, your jury selection, I think, starts like the 16th, but
Right.
that trial starts the 22nd.
Okay. Well, I don't want to get in the way of that. That's why March 21 might work.
Sure.
Along with some other murders out there. So we got to figure out which ones. Mr. Warner, have you been following what we've been saying?
Yes, sir.
Any questions?
No, sir.
All right. You ready to go?
Oh, definitely.
Most definitely. Okay. Well, we'll try to make it happen. Thank you for being here. You're free to leave the booth if you want.
Okay.
All right. Bye-bye.
Thank you, Judge.
You bet.
Hi, good morning, Judge.
Hey, Ms. Patel, how are you?
I'm doing well. How are you?
I am well. Thank you for patching in. All these folks dropping in. You have Mr. Gomez's case. Mr. Mann is sick and could not be here. So I just needed to know if February 2 was still good for you.
Yes, it is still good for me.
All right, we will communicate that to Mr. Mann. I wanted Mr. Gomez to be able to leave once we heard that. Mr. Gomez, do you have a phone number for your lawyer?
Yeah.
So you guys talk regularly. Okay. Well, right now we're going to see if we can get you a trial on February 2, but I'll let Mr. Mann know that and he'll let you know what all that means. Okay. All right. Thank you. You're free to go. All right.
Maybe.
Thank you, Ms. Patel. That was easy.
Thank you.
All right.
Have a good day.
And Judge, my attorney Larry DeLand, on behalf of Alexander Vitt, VEIT, you called him earlier, and I had another court I had to go to first. And I just wanted to check in.
Yep. I need to know what's happening with that case. I had been told by the state that it was likely a plea or diversion. And today was the day to do that. So I needed to hear from you what you thought was happening.
Judge, I reached out to Ms. Charles a week or so ago, and she indicated she had taken over the case. I had asked her to look at it for diversion because I thought it was appropriate in this case. She said that they would be looking at it for diversion, and I just haven't heard back yet.
Okay. Well, she happened to step out of the courtroom. Is she coming back? She must be. Her stuff's still here. Okay. So when Ms. Charles pops back in, we'll see what she has to say about it. Okay.
Thank you, Judge.
You bet. Now let's turn to Mr. Drain and talk about bond. Ms. Rivers, are you able to go on the record?
Yes, Judge, I'm ready.
Great. And Mr. Drain, is the green light on that microphone there?
Yes, Judge.
Great. If you could slide more towards the microphone so that in case Mr. Robinson wants you to say anything, the court reporter will be able to hear you. And I'm going to get your bond motion up in front of me in just a second. Here it is. All right. So Mr. Whitenauer, why don't you get us started? You are the movant. You can tell me what you want to share in general. I don't know if you've got a witness you plan on calling, and then I'll hear from Mr. Robinson.
Thank you, Judge. This is State of Georgia versus Torres Drain, 18 SC 161432. The defendant was indicted on August 21st, 2018 for 6 counts, the lead count being rape, and of equal concern would be another count of aggravated assault with a deadly weapon. Your Honor, while I've been working on this case, I had the opportunity to interview a female who advised that she had been a victim of rape and aggravated assault after the defendant had been granted bond and released on bond in this case. I'll just note that the defendant was granted a $90,000 straight bond on March 11, 2019, and the defendant was released from the Fulton County Jail on June 15, 2019, and has been out on bond since then. I would add, Your Honor, that this defendant is a convicted felon out of New York for strangulation in the 2nd degree with conviction date of June 20th, 2016. So given that history and these pending charges, we think that alone would be a sufficient basis to deny the defendant bond, given his risk of committing further felonies pending trial. Based on the interview that I had with this female victim, Alyssa Harris, that's ALYSSA, Harris, HARRIS, it appears that has come true, that he has committed further felonies. I interviewed her along with my co-counsel, ADA David, and an investigator in our office several weeks ago, hoping to learn more about the defendant, Mr. Drain, and specifically his possession of a firearm. She was not able to advise about whether he had a firearm on the incident date in this case, that being March 28, 2018. But she then did go on to advise that the defendant, after he had been released from jail and was living with her in an apartment in Decatur, that he assaulted her with a firearm, identifying that firearm as a silver and black 9mm Glock. I would note that the victim in the instant case, Miss Jasmine Brown, that's JASMINE Brown, when speaking with law enforcement, the Atlanta Police Department described the gun used against her as a silver and black Glock. Regarding the new allegation of an aggravated assault with a deadly weapon against this new victim, Alyssa Harris, who was at the time the girlfriend of Mr. Drain, they are no longer together. She indicated that while in the apartment in Decatur, Georgia, the defendant had threatened to kill and shoot her. Ms. Harris at that time was on her bed. The defendant was standing over her and put a gun to her head, pulled the trigger, and laughed, saying, "There's nothing in it." Of course, Ms. Harris was distraught, was crying, and asked him, "Why would you do that?" On a separate occasion, in the same location, that Decatur apartment, the victim and Ms. Harris and the defendant, Mr. Drain, had an argument. And after this argument, Ms. Harris was in her closet in her bedroom doing some housework when the defendant, Mr. Drain, came to her and inquired if she wanted to have sex, using words to the effect of, "Are you in the mood?" The victim, Ms. Harris, unequivocally indicated that she did not, saying no. At that point, the defendant became aggressive, pushed Ms. Harris, took her pants off, and then penetrated her vaginally with his penis. As she was not responding to this sexual assault, he eventually stopped, noting that words to the effect of, "You're not in the mood," and stormed off, and again, leaving Ms. Harris crying. Your Honor, based on these new allegations of the defendant committing new felony offenses, we are asking this court to revoke the defendant's bond because he has, again, violated the laws of this state, has been in possession of a firearm, has sexually assaulted another different female victim, and given his history of strangulation in the 2nd degree out of New York, we would ask that you revoke his bond and that he be held in the Fulton County Jail until this case is tried or otherwise resolved.
So it's two separate incidents that you described to me. The gun to the head, pulling the trigger, preceded the sexual assault, not by minutes, but they are two different things, different days, et cetera.
Yes.
Okay. And you learned about these because of an interview you had with Ms. Harris.
Yes, I interviewed Ms. Harris along with ADA David and Investigator Baker in our office on Wednesday, December 22nd at 11 a.m.
Ms. Harris has not brought these complaints to law enforcement.
She has not, but in my communication with her, in which we've had several, she does intend now to report these to the DeKalb County Police Department, which would be the proper jurisdiction based on the address of the apartment where these offenses occurred.
Okay, got it. All right, so your basis for revoking would be one or both, either would be sufficient of the alleged incidents.
Yes.
Okay. You're making a proffer right now. Is Ms. Harris available? Should Mr. Robinson want to talk with her, or has she let you know her thoughts about interacting with Mr. Robinson?
We have not had any conversation about speaking with defense counsel. If she did want to, if he did want to speak with her, and I assume he would, in preparing for this trial, certainly we would make her available for that purpose.
The 413 hearing, which we have scheduled, I believe it's for the 21st. Yeah.
Yes.
Were you planning on proffering the same information or having Ms. Harris testify at the 413 hearing?
In line with my general practice, I was planning on making a proffer to the court. But I am relatively new to your courtroom, Judge, and if that would not be accepted by the court, I'd be prepared to place her on the stand.
It's not acceptable or unacceptable. I defer to the prosecutor to decide how he or she thinks they'll be most persuasive. Sometimes an issue comes up where I make a preliminary finding that the state could meet its burden of proving by a preponderance that the other act did occur, but we might need to have some testimony before that witness testifies under oath, but outside the presence of the jury, if there's, depending on what the nature of the concern of the defense is. I'm not requiring Ms. Harris to be present on the 21st or not. I just wanted to know what your plan was.
That is my plan as of now. Yes, Judge.
Okay. All right. Mr. Robinson, share with me your thoughts about this. And I recognize that you may be hearing some of these same details for the first time like I am.
Yes, Your Honor, may it please the court. Your Honor, both Mr. Drain and I were very surprised when we learned that the allegations were allegedly coming from Ms. Harris. And Ms. Harris was the person who retained me to represent Mr. Drain. We had regular contact both during his incarceration and subsequent to him making bond. They were together for a subsequent period of time, and I think that was a significant period of time. So I was eager to try to get a sense as to where the dates are, such that I might be able, if necessary, to cross-examine her concerning certain communications that the two of them had throughout the course of their relationship. I believe that those communications would be central to an assessment of her credibility and whether the standard of preponderance of the evidence is met and whether the evidence should be admitted and whether Mr. Drain's bond should be revoked. So I was surprised that it was from Ms. Harris. I was a bit surprised that, notwithstanding having made this disclosure to the prosecutor, there hasn't been any pending charge. My expectation was that if, given the serious nature of this, that she would take those complaints to the DeKalb County Police Department, and they would likely issue a warrant for Mr. Drain's arrest, and we would address this matter under different circumstances. I was under the impression that from the time I found out about it last week until today, she likely would have done that. Apparently, she has not done that. I don't know if there's an intent on her part to do that before our hearing on the 21st, but I would submit that the matter should be tabled to the 21st. One, to determine whether the state is going to present her and give me an opportunity to effectively deal with these. There's almost no way I can deal with a proffer. There's no way that a proffer cannot be a preponderance of the evidence because we have an officer of the court stating it. And so my only way to even contest either the admissibility of the 413 or revoking Mr. Drain's bond is to cross-examine the complainant. So I would hope that I would ask the court to defer this matter to that hearing. And also, in addition to giving me an opportunity to effectively cross-examine and represent Mr. Drain, it gives an opportunity to see if these very serious charges move forward and become pending. If they do, then that presents a completely different scenario. And I would submit a scenario under which it's probably likely that the bond would be revoked at a minimum, whether or not the evidence is admitted as 413, because at that time there would have been some determination by a judicial officer, a law enforcement officer, as to the cause for there to be a warrant issued for Mr. Drain's arrest. So that would be our request, Your Honor. I'm glad to have gotten some information. I still have not gotten the dates. Maybe I missed something, because there was a long period of time that Mr. Drain and Ms. Harris were intimate, and then there was a period of time where they were cordial. And I would like to be able to speak to that period if these events occurred within that context. That would be my request of the court, Your Honor.
Okay. I don't think you missed the dates because I didn't get anything either. And it may be that Ms. Harris has a little trouble recreating specifically when things happen, but I do want to revisit the timeline with you a little bit, Mr. Whitenauer. So Judge Reeder granted Mr. Drain a bond in March of 2019, which he eventually made. These two situations, these allegations, the gun to the head and then the sexual assault, those both occurred after Mr. Drain posted Judge Reeder bond and moved into an apartment with Ms. Harris. Is that correct?
Yes. So given the time that has passed since these events, it's fair to say that no, Ms. Harris does not recall the exact date that Mr. Drain committed these acts. And I think, so I can provide a window of the dates, which would be between June 15th and 2019 and March 11th of 2020. Now, the reason I know March 11th, 2020 is going to be the end date for these incidents is because it was on that date that Ms. Harris went to the courts to file for a temporary protective order, which was granted. And that temporary protective order came about because 2 days earlier, Mr. Drain had battered her by punching her on the thigh while she was pregnant. And that was the final straw. Ms. Harris explaining that when she learned that she had become pregnant, that she had a conversation with Mr. Drain and that he, in some words of form, indicate that he would no longer hit her. And then when he did, on or about March 9th of 2020, she said, that's it. And then reported that to the DeKalb Police Department. We are in the process of obtaining that police report, and then went and obtained a temporary protective order, which was granted and valid until I believe sometime in October of the same year. As Your Honor knows from hearing other cases involving sexual assault and domestic violence, victims don't always share the fact that they have been sexually assaulted or abused by a defendant. And in fact, Ms. Harris is like many of those victims, in that there were several incidents of physical violence against her that she shared with us And it was only after discussing those that she then made an unsolicited outcry of rape. And I would note, and ADA David is here on this call, and she can verify that while discussing this incident of rape, Ms. Harris became visibly emotional, began crying, pulling her glasses down from her face and using a tissue to dry those tears. So, we had a good reason to believe Ms. Harris based on her presentation and based on the fact that she was able to independently describe a gun, silver and black 9mm Glock, which happens to be the same kind of description that Ms. Brown gave to police officers when she alleged that he had placed a gun to her while he raped her. While I understand it is a proffer based on an interview of Ms. Harris, and we do have a good faith basis for moving this court to revoke his bond, as we do believe he presents a real and grave threat to our community by committing further felonies.
Okay. I appreciate what you just shared. I'm not particularly troubled that there's not a specific date. I understand very much why Mr. Robinson wants to try to cabin this somehow, and you've cabined it to a certain extent. It obviously is sometime after mid-June of 2019 when Mr. Drain got out, but then it would be before early March the following year. Still a somewhat big window. I also understand, I don't find it particularly remarkable that Ms. Harris didn't run immediately to the police. Some people do, some people don't. And she falls in the category of don't for reasons that are not surprising based on what we've come to learn about victims or alleged victims of sexual assault. So I get that. Mr. Robinson, why don't you tell me, or Mr. Drain can, a little bit about what Mr. Drain is up to these days? Is he working? What are his hours? What are his responsibilities? Because that will help me fashion what I think might be appropriate restrictions between now and our 413 hearing if I'm not going to revoke bond.
I think Mr. Drain can better speak to what he's doing day to day for work and those things. I haven't really discussed.
So Mr. Drain, talk to me a little bit about whether you're gainfully employed, if you are, what you do, what your hours are. I will note for the record, you arrived with a young lady and a small child. So if that's your kid, tell me what your family responsibilities are, et cetera, so I can understand a little bit more about what's going on in your life. And to be clear, I'm not asking about Ms. Harris in any way. I'm asking about what you're up to in early 2022.
Okay. I do work for UPS part-time. I started school online at CTU for logistics and supply chain management. That's my wife, Mia. That's my daughter. And I have a stepson that's 4 years old.
What are your hours at UPS?
No more than 30. We also do DoorDash. So no more than 30 hours. So I'm part-time. And
but do you work Monday, Wednesday, Friday?
Oh, no, it's Thursday, Friday, Saturday, and sometimes sometimes Sunday.
But are you at a warehouse or are you driving a big brown truck?
It's a warehouse in Hotchkiss, Illinois.
Where do you live? Where do you live?
In Illinois.
You live in Illinois?
Yes.
Oh, okay. So you came here today or yesterday for this court appearance?
Yes, never missed.
Okay. Illinois. So you don't commute from here to a warehouse in Illinois. Got it. And then you're saying you and your wife also do some DoorDash?
Yeah, we do it. Actually, all four of us, we usually get in the car and we do DoorDash.
It's a family, family delivery.
Yeah.
Okay. And so you and, is it Ms. Drain or did she keep her last name?
It's Kelly Drain, Kelly-Drain.
So Ms. Kelly Drain and you have one child together, and then she brought into the relationship another child.
Yeah, she had a 4-year-old. I met him at 2, but he's 4 now. His name's Elias.
Okay, so the 4 of you are the family unit. You work part-time at a warehouse in this place in Illinois.
Yes.
But then also you as a family do DoorDash.
Yes.
And does Ms. Kelly Drain do other work or just the DoorDash besides taking care of all the kids?
Yeah, that's it. Just the DoorDash with us and then take care of the kids.
And when did you move to Illinois?
In March.
March of
2020.
Okay. And I'm assuming, Mr. Robinson, that pretrial services, it's a straight bond. So I guess Mr. Drain just needed to let the bonding company know. He didn't need to let any agency know that he moved.
Yes.
That's my understanding, Your Honor.
Okay.
And Mr. Drain has been in regular contact with me via phone, text, and email throughout.
You live in Dyer or Frankfurt?
Frankfurt was my old address. We actually live in Hanover Park, Illinois. Dyer, Indiana is where my mom lives, but
yeah, that's Indiana, not Illinois.
Yeah, I didn't know how to do the e-file. I kept calling. They told me to go online, but they also told me that when I came here that I can fill out paperwork here. And
yes,
so that's
you
what
need
we're
to do
gonna
that because we don't have a good address for you. We've got an address in Dyer, Indiana, which sounds like is your mom's place, and then a place on Jackson, whatever.
Jackson Branch, Frankfurt, Illinois.
Yeah.
Yeah, I had to get a new ID. That was an old address.
Okay. So you'll need to update your address with the clerk's office because otherwise we're relying on Mr. Robinson to track you down. And he's good at that, but it gets harder for him the further away someone lives.
Yes.
So
Judge.
please work with Mr. Robinson and the clerk's office here in this building to make sure we get a new address for you.
Yes, Judge.
All right. How long have you had the UPS job?
I've been there for about 6 months now, for as long as my daughter's been alive.
And it's always been part-time?
Yes.
Are you trying to make it full-time?
I was trying to make it full-time, but I'm actually about to start school, online school, in March when I was done paying my FAFSA.
What's that?
It's kind of like a federal student aid loan. And I had to catch up on some payments. So I'm done in March and they also allow me to come back in March.
Okay. And then you'll be back in school.
Mm-hmm.
And how will you all put food on the table if you're a student?
It's online. So, and UPS is going to pay for it.
Okay. So you can keep doing the UPS work, but it needs to stay part-time because you've got school as well. But because it's logistics, UPS is helping cover the cost.
They're paying my whole tuition.
Okay. All right. Mr. Whitenauer, do you have any questions about Mr. Drain's current situation that I didn't cover? You may not be interested in it, but I was, and I got the information I needed.
No, Your Honor.
Okay. All right. So I'm not going to modify your bond at this point. I'd forgotten that you were not an in-state resident, and I just reviewed Judge Reeder's bond again. You're not subject to any supervision. You're subject to the bonding company tracking you down if you don't come to court. So at this juncture, I'm going to leave your bond as it is. This shouldn't surprise Mr. Robinson or you, Mr. Drain, that I'm very concerned about these other allegations and am going to learn more about them when we have our next hearing, which is coming up on the 21st. You, Mr. Drain, should talk with Mr. Robinson about how you're going to be here for that, whether you bring your whole family or not. I'm going to require you to be at all further court proceedings. So you'll need to be either here in court, or if you want to be with Mr. Robinson in his office, if he isn't coming down to court, that's fine. But you can't appear from Illinois. You'll need to be here in the metro Atlanta area. I'm going to basically take Mr. Whitenauer's motion under advisement. I suspect we'll learn more about the situation and the allegations involving you and Ms. Harris. And I will reserve the right to grant the motion as I learn more about those two situations, the alleged aggravated assault and the alleged sexual assault. And Mr. Whitenauer, I want to be clear, I'm not requiring you to produce Ms. Harris for the 413 hearing. So it may be that you rely on the records you made today. There's not a whole lot more to add. If you have anything that is discoverable about Ms. Harris, I don't know if her interview was recorded or anything like that. Obviously, you need to get that to Mr. Robinson, along with some basic contact information so that she can either speak with him or affirmatively indicate that she's not interested in speaking with him. But I do want to make sure Mr. Robinson is getting access that he's entitled to this 413 information. I do think, given this revelation that the state contends that there's a second sexual assault, that keeping this case as a trial for February 2 makes a whole lot of sense, because it may not be until Ms. Harris testifies that I get to the point that I say we do need to address this bond situation. And it could be that Mr. Whitenauer decides, well, she's going to testify on the 21st, but he may, for all sorts of sound reasons, say she'll testify, assuming the 413 comes in, and it's not a very high bar to get 413 in, that we learn more about what Ms. Harris has to say at the trial. And as Mr. Robinson pointed out, the whole calculus changes if all of a sudden there's a warrant for Mr. Drain out of DeKalb County. And I'll certainly factor that in as well. Mr. Whitenauer, you want to add anything, either argument or presentation, now that I've ruminated a little on the record and you got to hear what Mr. Robinson thinks about this?
Your Honor, there's not much to add about either of those particular incidents. I would just say that they are one of two of many incidents committed by Mr. Drain. I continue to speak with Ms. Harris about these allegations. I anticipate her going to the DeKalb County Police Department. I do think that there, in addition to charges for these two incidents, there may be additional charges for an aggravated stalking based on continued contact by Mr. Drain with Ms. Harris after the TPO was issued. I understand that Your Honor is not inclined to revoke his bond today. I would just ask that Your Honor consider obtaining from the defendant a waiver of extradition based on his announcement that he is now living out of state, should there be an issue about getting him back here to Georgia for future dates.
Okay, that's a good point. Let me observe this. It wasn't your case back then, and it may not have hit anyone's radar in the Fulton County District Attorney's Office, but an inflection point for Mr. Drain's bond was probably more so in March of 2020 when Ms. Harris got the TPO. Had that been brought to light to, I think it would have been my case by then. I think Judge Reeder was off it by then. That would have been, in some ways, a more directly actionable item, because Ms. Harris had taken that affirmative step. And to Mr. Robinson's point, a judicial officer in DeKalb County had processed it and said, yep, I'm going to grant this. That whole process was markedly inconsistent with, meaning what led to getting the TPO was markedly inconsistent with Mr. Drain's conditions of bond. But that is now almost 2 years old, and I haven't heard that something has happened since that time. To be clear, the allegations that Ms. Harris has made through the district attorney's office that predate that are much more severe. But right now, they are sufficiently sensitive from a procedural standpoint that, like I said, I'm going to leave Mr. Drain's bond as it is. Tell me, this waiver of extradition, you mean simply, Mr. Whitenauer, if there is a warrant sworn out by law enforcement in DeKalb, sort of my comfort level with letting Mr. Drain go back to Illinois, your argument is, should be conditioned on Mr. Drain making clear, look, if there's a warrant for me, I will come back to Georgia and deal with that. And maybe Mr. Robinson gets me a bond in DeKalb, maybe he doesn't, but I'm not going to fight it from Illinois. I would fight it from Georgia. Is that a fair summary?
That is a fair summary, and we'd also ask that you modify the bond to include no contact with Miss Alyssa Harris.
Okay, I was inclined to do that when I was starting to ask about what work was, but that's when I was under the mistaken impression that work at UPS would be here in Atlanta and not in Illinois somewhere. Mr. Robinson, share with me your thoughts, please, about the waiver of extradition. That would give me some comfort. Because one thing I think I might do is modify the bond to say you need to be in Metro Atlanta and not in Illinois if I'm not confident that we could get Mr. Drain back here to deal with the different things he needs to deal with.
I don't see where a waiver of extradition is inappropriate, Your Honor. I would think it would be appropriate.
Okay. Logistically, how do we do that though? Mr. Drain, when are you slated to go back to Illinois? How'd you get here?
We drove.
Okay. And are you staying in a hotel or with friends?
No, we're staying with her parents.
Whose parents?
My wife's parents.
Okay. So then what I'm going to do is direct that Mr. Drain remain in your wife's parents. They live in what town?
Jonesboro.
Jonesboro. Okay. You're going to remain in Clayton County. That's where Jonesboro is until two things happen. One, your address is updated in the system. So I'll need to see that it's updated. And two, Mr. Robinson executes a waiver of extradition on your behalf, which simply means if there is a warrant for you, either because I decide to revoke your bond or something comes out of DeKalb County, you will not fight extradition, which doesn't mean you admit to anything. It just means that if DeKalb County or Fulton County reaches out to whatever local law enforcement is where you live in Illinois, they say, hey, we need Mr. Drain. You'll say, I will go peacefully with you and get transported back to Fulton and or DeKalb. That's what a waiver of extradition would be.
I believe that we could, if the court is going to be modifying his bond, we could just simply put that in the bond that the defendant hereby waives extradition.
I had that thought too. Do you think, Mr. Whitenauer, that would suffice if I entered a bond modification, and that actually could take care of the address change as well, that requires Mr. Drain to live at whatever the address is now in Illinois, and he agrees not to contest extradition to Georgia in connection with this case or related charges?
Your Honor, I don't know the answer, but I'm just thinking about it that while you might be able to order someone to waive extradition, unless there's some acknowledgement by him that he is consenting to that condition, I just thought that perhaps a separate waiver of extradition that is filed with the court and signed and acknowledged by the defendant would be his affirmative relinquishment of certain rights in another state.
Sure. That's probably cleaner. What I'm going to do is ask you to draft it up, Mr. Whitenauer, and shoot a copy to Mr. Robinson so he can say, I'm fine with my client signing this. And then we would need to get Mr. Drain to sign that before he heads back to Illinois.
Yes, Judge.
Okay, so I'll leave that to you guys. And then when you've got a signed copy of it, Mr. Whitenauer, let me know. And that'll be condition 1. The condition 2 is this change of address form that Mr. Robinson or we may have them here. Do you mind looking, Mr. Parrish? Are there change of address forms? Great. If you just get one to Mr. Drain, you can fill it out now, Mr. Drain. He's got a pen now, courtesy of Ms. Wood.
Thank you.
All right, great. So I think that's it. Mr. Whitenauer, anything else?
Not this time.
All right, so we will see you, Mr. Robinson, and your client on the 21st. I leave it to you as to the logistics. You are welcome to be here in court. If you want to appear virtually, that's fine. Mr. Drain needs to either be here in court with me or with you in the same room, meaning your offices.
Yes, Your Honor.
Okay. All right.
Are we excused, Your Honor?
Almost. Mr. Drain is filling out his
Okay.
change of address form. Did you do everything you needed to do?
Yes. Thank you.
Great. Okay. Do you have any questions, Mr. Drain?
No, Judge.
So you need to stay at your in-laws' house until you've signed that waiver of extradition form, and then Mr. Robinson gives you the thumbs up that the state has it and the state's okay with it, okay?
Yes.
Any questions about that?
No.
All right, Mr. Robinson, you've got good contact information for Mr. Drain?
I do, Your Honor.
Okay, thank you, everyone.
Thank you.
All right, let's get back to our list. Took care of Brooks and Drain. Wolf. Ms. Wood, have you had a chance to talk to Mr. Cole?
Yes, Judge. And I also spoke to Ms. Charles. I don't believe this is going to be a trial. However, after speaking with Ms. Charles, she would like to keep him with Mr. Wolf. So I don't know what day Mr. Wolf's cases are on.
So 216, and we'll keep Mr. Cole. He'll be with Mr. Wolf, because what Ms. Charles has said is if Mr. Wolf wants trials, the first one she's going to try is your client's case. We're putting that down for the 16th. So if Mr. Manetas is going to arrange a global resolution of Mr. Wolf's cases, it had to be before then. And so I guess you'll just want to keep in touch with Ms. Charles and Mr. Manetas so that Mr. Cole is moving along in sync with that. Okay. You bet. He is.
Your Honor, could we loop back to position 15 when you have a chance?
Sure. Ms. Grant.
Yes, I did communicate with Ms. Beza. The discovery had been served on Mark Gaffney, who never provided it to Mr. Franklin.
Okay.
So I'm meeting with Ms. Beza this Wednesday for her to reserve everything, and then we'll take it from there in terms of how voluminous it is.
Sure. And I will 100% defer to you. This seems to be your big one on the calendar. And so if you can be ready by the 21st, that's great. But I have no idea what the discovery is like. And
Sure.
it's unfortunate that it got stuck with Mr. Gaffney.
Right.
Okay. Did you have, that was it?
I do have a couple more announcements. Position 24. The big hangup in resolving this case is that it's his first felony, it's the taking of a cell phone. And so I've asked Miss Charles to consider diversion, and she's going to speak to, she has a few cases, she's gonna talk to Miss Toole about whether they would qualify for adult diversion. If it doesn't, my desire is to wrap up the outstanding CP in a global resolution.
Okay. If it is diversion for the indicted case, then the CP is just going to sit out there and it will go where it goes.
Correct.
Got it. So we need to give Ms. Charles some time to get with diversion, because that is also maybe gonna, and we're gonna do Mr. Veet in just a second, but that may be in the same posture. Yes? Okay, all right. So you want to let Mr. Richardson go, but what date should we put this on as a forcing mechanism to make it happen?
The second, Your Honor.
Okay, great. All right, we'll do that. Is Mr. Richardson still here?
Yes.
He is. Okay, so you can release him whenever you want to release him.
You're free to go.
All right. What else? Was that it? Heavenly
Position
Mitchell.
One on the supplemental.
Yeah.
The reason for the contact break is that my client was receiving psychiatric services. I will be asking for a later date only because of that information. I just need to get those records, make sure that there isn't any issues of not filing an evaluation. I really hope that that's not necessary, but given the length of the stay, I have some concerns with that.
Okay. But you and Mr. Mitchell had a good conversation and have
Yes.
resumed contact.
Yes.
Okay. So March 21.
Yes, Your Honor.
Okay. Ms. Beza, were you able to hear what Ms. Patel shared?
Yes, Your Honor.
Okay. So Ms. Patel, you will the way we'll know, I guess, is if you file a motion that's going to slow things down, I'll grant it, and we'll make sure that the right stuff happens with Mr. Mitchell. Otherwise, March 21, I know that date works for Ms. Beza, and it'll work for you. Okay. All right. Great. Okay, that's that update. Let's talk about Mr. Veet's case, because I know
Your Honor, may I be excused?
if you're done.
Thank you, Your Honor, I am.
Okay. Mr. Deland, you still with us?
Yes, sir.
All right, let me find, that is 16. So, Ms. Charles, what are we doing with Mr. Veet?
Similar to Mr. Richardson, Your Honor, it's my understanding that the prior ADA and Mr. Dillon had worked out that this might go to diversion, and I'll need to first confirm that, and then if not, submit a new referral to with Mr. Toole to confirm that he can go into diversion for this case.
Okay. Mr. Deland, would this be Mr. Veet's first felony case?
Yes, sir.
Okay, all right. How much time do you think you need to, I don't know how quickly Ms. Toole turns these things around.
I would say, Your Honor, I would be talking to her today. I would try to go down to her office, and we can set it for the 2nd as well.
Okay.
And that will give us a date certain.
All right. So, Mr. Deland, the plan is I'm going to put this as a case that's ready to go to trial the week of February 2. Well, on February 2 would be when we pick the jury. But that is more as a placeholder and a focusing mechanism. It sounds like your hope is that the district attorney's office will divert this case. And if they won't, that it's still a likely, it might be first offender, who knows what. I won't get in the middle of that, but you want to give Ms. Charles a chance to see if that'll work.
That works for us, Judge.
Okay. Mr. Veet, do you have any questions?
No, thank you.
All right. Then Mr. Deland, we'll just, Ms. Charles will keep you in the loop, and then she'll let Ms. Nelson know what we're doing.
Thank you, Judge. May we be excused?
You may. Thank you. All right. That took care of that one. We still have some people. Who's in 7 South? Let's figure that out.
Judge,
Yeah,
I believe that's Mr. Robinson, position number 19.
great. Hey, good morning. Who's in 7 South?
Tyrone Robinson.
Oh, I can't believe it just.
Tyrone Robinson.
I heard you. Thank you. I messed up over here. There you are. All right, Mr. Robinson, we are trying to track down your lawyer, Ms. Taylor. Ms. Nelson, do you have an update?
Judge, I just resent her the link about 10 minutes ago. Let me call her office again.
Okay. So, Mr. Robinson, your case is right now set for trial on February 16th. You've got a co-defendant, Max Pritchett, who will be ready to go to trial that day, I hope, and a Lauren Riley as well. I don't want to talk about the substance of your case at all. That's for you and Ms. Taylor to talk about. I also don't want to keep you sitting around too long, but we're going to give Ms. Taylor one more try, see if we can get her on the call so she can let us know what's happening on your side of things, okay?
Yes, Your Honor.
Appreciate it. I'll be back. Don't leave till I say it's okay, all right?
Yes, Your Honor.
Thanks. Okay, anyone else here in court waiting to talk about a case? Nope. Anyone online? Oh, Ms. Rockwell and Kimber, what are we gonna do with that? Because Mr.
Good morning,
Kimber.
Judge.
Good morning.
I guess it's morning.
It is. You got 20 minutes left of the morning. So Mr. Kimber's got 2 cases here and apparently 2 more in the hopper. What are we doing?
So what I wanted to communicate with the court is the idea that Madam Prosecutor had, which sounded very reasonable to me. A global resolution is really what's needed, Judge, but the state is waiting on the crime lab for one last case, which it's going to be the difference between it being a trafficking and not a trafficking, Judge, which will drive the train. So Madam Prosecutor suggested that we ask for a status conference and not a trial, because it doesn't make sense to just take care of half of his problems.
Is he, Mr. Kimber, in a no bond status on at least one case? Because I'm happy just to revoke the bond on one of these. I don't want Mr. Kimber going anywhere until we have the global resolution.
Let me check. I believe so, Your Honor. Let me.
I can check. I just wondering if anyone knew.
Well, of course, I wouldn't be making that motion, but I understand the court's position. And what doesn't make sense is for him to be technically on bond on some cases and in jail on other cases.
Right.
That doesn't help. That doesn't help his credit with the DA time.
Yeah. In fact, he has a bond hearing today. You may have already had it. He was supposed to have a bond hearing at 9 this morning with Judge Borski. What happened in there?
Nothing, Judge. Nothing happened. There's too much going on with him. And I mean, I could sign in, but knowing Judge Borski and knowing the temperature of the state, and when there's so much going on, when I asked for the bond hearing, somehow I got the trial notice or the status notice from Your Honor also.
Okay. It looks like in one of the CP cases, he has a bond. So I think what I'm going to do is revoke his bond in the 2 cases that are on the trial calendar, and I'm assuming he has a bond in the second one, but the first one I know he does. And to Ms. Rockwell's request, turn this more into when do we get everyone back in here for a status update? as opposed to putting it on a trial calendar, because Ms. Rockwell is saying it's not going to be a trial. It's just a question of, is there a mountain of time because it's trafficking quantity, or a hill of time because it's still 4 cases, but there's not trafficking in there?
That is correct.
Is that a fair summary of what you're asking for, Ms. Rockwell?
Well, I mean, I would love for everything to just go away, but I know that's not going to happen. So,
Okay, right. Assuming that that magical event does not occur, then I think that's what we'll do here. And how much time do you want, Ms. Charles, to rattle the crime lab's cage to get results on the CP case?
Say February 16th. Could we get a status then?
Okay, I don't know that we'll meet then, because that's when we'll be picking a jury, but you're saying
Around that
middle of next month.
Middle of next month, yes.
Okay. Is there, I know you'd like it sooner, Ms. Rockwell, because then Mr. Kimber gets some certainty. Are there other things going on in his cases, or are you okay with a sort of mid-February status? Did we lose Ms. Rockwell? Nope, she's still there.
Judge, with me.
That works for you? All right. That's what we will do. Mr. Kimber is here. Do you want him to come out and just stand in the doorway and we tell him this, or would you prefer to break the news to him in your own way?
I will communicate everything with him, and also with his family. His family wanted to sign in, but I didn't have permission, but I'll tell his family and let everybody know.
Okay. Sounds like a plan. Thank you so much.
Thank you, Judge. May I be excused?
Yes, ma'am. All right. Oh, Ms. Taylor is here.
Yes, Judge. Good morning. Happy New
Good
Year.
morning.
to
Hold on one sec. I'm going to get Mr. Robinson back on this audio. There he is. All right, Mr. Robinson, we have Ms. Taylor. She is the Lincoln lawyer today. I don't know what kind of fancy car she's driving, but she's working out of the back of her fancy car there.
Yeah, Judge, and I'm parked, so we're not moving. I'm stationary. And Judge, I apologize. I did not get any kind of notification. This case was on the calendar. I didn't get an Odyssey notification or nothing from the clerk's office or anything that this case was on the calendar today. So that's why I was not prompt in being present either on Zoom or in the courtroom on this case. Your office did contact me and just send us the Zoom link. So I apologize. I'm going to get with Odyssey to see what the problem is as to why I'm not getting a notification.
Okay, well, we'll keep you focused on this one because this is one that looks like it's going to trial soon.
Yes.
We talked with a couple of the other lawyers in the mix on this case, and we're looking at February 16th, February 1/6, for picking a jury in Mr. Robinson's case. His co-defendant, Mr. Pritchett, we need to get back into county custody. He's in state custody right now. The co-defendant, Ms. Kalish, has been severed out and will not be going to trial at the same time. And TBD about Ms. Riley, but currently she is set to go to trial on the 16th of February as well. State has announced ready, and so I just need to make sure, Ms. Taylor, you'd be ready if reached on February 16th for Mr. Robinson. Okay.
Yes, Judge. Right now, Mr. Robinson maintains his not guilty plea, Judge. So we will be ready when reached. And now, Mr. Robinson, I'll get with you at the jail this week and we'll talk. At this point, Judge, yes, we would say February 16th, we will be ready if reached.
Excellent. Well, you'll be getting an email, Ms. Taylor, that shows you the order in which there'll be a handful of cases that we'll be calling in on the 16th. rather than the whole bunch we called in today, since the dust has started to settle as to who's pleading, what cases can go when. And this will be one that is on for the 16th. So you'll get an email. We know that works for you. And that'll let you know a little bit more about what to expect for February 16th.
That's fine, Judge. Thank you.
All right, Mr. Robinson.
I'll go ahead and put it on my calendar for February 16th, and then I'll look for the email from.
Good. Yeah, block it out now, and we'll get you the email. Mr. Robinson, you and Ms. Taylor will talk about the substance of your case. You have any scheduling or procedural questions for me?
No, Your Honor.
Okay. Well, Ms. Taylor, like she said, she'll be out there to visit you soon. You guys can talk more about the case, okay?
Yes, Your Honor. Can I be excused?
Yes, sir. Bye-bye.
Thank you, Judge. That's all I have then. May I be excused?
Yes, ma'am.
Thank you, Judge. Y'all have a good day and Happy New Year.
All right, you too.
Doesn't have the excuse as well.
I think everyone can. I think we're done. Look for the email, and we will be flexible about all this. Dates may shift because of COVID, et cetera. I think the soonest thing we'll be hearing will be from you, Ms. Charles, about diversion in a couple of these cases. I'll need an order that puts them in diversion, whether that comes from Ms. Toole or you. I'm neutral. But it needs to have real clear deadlines because Ms. Nelson tracks those. So I'm making it up, but in Mr. Veet's case, if it was, you've got 6 months to take these classes or complete the program, however it works. I know under our new DA, there's a different approach to diversion. I require there to be a deadline because if it's amorphous, everyone forgets about the case. And if Mr. Veet did a bad job, he needs to come back here and deal with his case. But you're going to forget about it because it's not your case anymore. It went to diversion. Ms. Nelson doesn't forget about it. And so she'll have this deadline and she'll say either you need to dismiss it now because he was successful, or you need to say, put it back on the trial calendar.
Understood, Your Honor.
Okay.
Thank you. Yes.
Great. All right. Thank you, Ms. Patel and Ms. Wood. Thank you, Ms. Tucson. Another great appearance. Low impact. Someday we'll get some pleas you can help with. But good. Good. Thank you, guys.
Yeah, back to Mark.
Thank you, Ms. Rivers.
You're okay. Okay, Judge, have a good afternoon.
You too, Ms. Nelson. I'll be calling you.
Okay, thanks, Judge.
We'll be.
Judge, are you still on the bench?
I am.
I have a question about a case before I file it. That needs some clarification on.
All right, hold on one sec for that.
Okay.
And I will hear you out. I want to see if the lieutenant's on because we're done at the jail end. So thank you, Lieutenant, if you're still on. I don't think you are, but good work. All right. Yes, Ms. Rivers.
It was Stacey Dewan Carter. He was a juvenile at the time that the case was first presented, but when he took the plea this year, it didn't indicate anything about sealing it when I filed it. And I just want to make sure before I file it that I'm
What's the case number?
17 SC 156244.
Dewan Cannon?
Yes.
And you did a transcript of his plea?
Yes, I did. I haven't filed it yet.
I'm just looking him up.
Okay.
And I didn't have any. So I was just. Or, I mean, bye.
Oh, I was trying to remember this case. You don't have to file anything under seal. He was very much over 17 when all this stuff happened.
Okay, great. I just wanted to double check.
Yep, we're good to go.
All right, thank you.
Thank you.